Hello and welcome to the second video on the Occupiers Liability Act 1957. We saw in the first video that for there to be a duty, you simply need an occupier, a lawful visitor, premises, and damage caused by the state of the premises. So once you have a duty, what is the duty? Well, under section 2.2, you must take reasonable care to see the visitors will be reasonably safe using the premises for the purposes of their visit. You need to learn this definition and make sure that you always have two reasonables, and that's how I remember it: two reasonables. Section 2, subsection 2. This is commonly known as the common duty of care, and it is not a duty to make the premises completely safe. It is just to take reasonable care to see that they are reasonably safe, and Laverton and Kia Pasha takeaway confirms that. The only way to have made the takeaway completely safe while it was raining was to have shut it. The steps that they took in mopping the floor and putting up a sign were sufficient. Once you've established that what the duty is, you need to know if you need to take more care or less care. And you need to take more care of children because you can expect them to be less careful than adults, so you owe them a higher duty of care. So in these three cases that we talked about, we saw that there was liability. In the first one, Maloney and Lambeth, there were liability for the gaps in the banisters. In Glasgow Corporation and Taylor, there was liability for the poisonous berries in the park. And lastly, in Jolly and Sutton, there was liability for the boat that had been left on council land. However, there are some times when children can be expected to be supervised by their parents, and this was confirmed in Phipps and Rochester Corporation, where there was no liability because the parents of a 5-year-old had failed to exercise proper control over their child. A situation where the occupier may take less care is where an expert comes onto their premises and is then hurt. Under section 2.3b, an occupier can expect an expert to appreciate and guard against special risks ordinarily incident to his job. This means that an expert should realise what the risks are that are incident just means related to, so closely related to the job. Rolls and Nathan. And this means that you owe experts who are hurt a lower duty of care. And in the case itself, there was no liability because the chimney sweep should have been aware of the danger of carbon monoxide poisoning, and they'd also been warned about it separately as well. So in a scenario, you are looking out for an expert and you are trying to identify someone who's been hurt, who is an expert, who should have known better really, and whether the risk was something that they should have realised and taken more care of themselves. Then we're going to look at breach. The occupier has to reach the standard of a reasonable occupier. If you have time, do the risk factors very, very briefly. In this situation, is harm likely and could it be serious? This is the same as in negligence. Then you're going to consider whether, in fact, the occupier can say that they're not liable because either they've given a warning under section 2.4a or they can blame an independent contractor under section 2.4b. So let's look at warnings first. A warning has to be enough to enable the visitor to be reasonably safe. And the warning in Ray and Mars was not enough to enable a visitor to be reasonably safe, as it was inside the entrance to the pit and it was in the dark. However, you don't need to warn against obvious risks such as cliffs, and that was confirmed in Cotton and Derbyshire Dales. The last very important section is the one dealing with independent contractors. Under section 2.4b, you can avoid liability where the injuries are the fault of an independent contractor. So someone who has come onto the land, done a job, gone away, and then someone else has been hurt. There are 3 conditions that must be satisfied. First, it must have been reasonable to hire an independent contractor. And in Hazeldean and Dorr, it was held to be reasonable to hire a lift contractor, as this was specialist work. So if the job in the scenario is something reasonably difficult, then it's probably reasonable to use an independent contractor. The occupier must have taken reasonable steps to satisfy himself the contractor was competent. So you can't just drag in any old person off the street. In Bottomley and Todmorden Cricket Club, This was not proved because the occupier hadn't checked that the contractor who was going to run a fireworks display had insurance. So here, just think about sensible things that they might have done. Did they take references? Did they check that the person was competent in some way? Did they come highly recommended? What further steps could be taken? And then the last thing that you have to show is that the occupier has taken reasonable steps to satisfy himself that the work has been competently done. This just means discovering obvious risks, not going into great detail about whether something's been done properly. So in Woodward and the Mayor of Hastings, the occupiers were liable because steps that were left icy after snow was cleared by the contractors was obvious. They should have noted that the steps were still slippery. However, if it's a really complicated job like a repair to a lift in Hazeldean and Daw, you would not expect the occupier to go and check it. Similarly, if it was on a roof or somewhere very difficult to get to. Once you have completed choosing the relevant sections, it's important to note that it could be more than one. Then you will have made sure that you've got the right marks. So the choice that the examiner is looking at really is he going to focus on children? Is he going to focus on an expert? Will he have a warning? Or might that be an independent contractor in the scenario? And as long as you are choosing the right one, then you should get the marks. The difference between experts and independent contractors is that an expert will come to the premises, complete a job and hurt him or herself, whereas an independent contractor does the job, goes away and someone else is hurt. When you're doing a longer scenario, you need to think about finishing off your answer. So when you've done your A and B, which you've done of your A, B, C, D of negligence, you will think about C, D and D. C is causation, but I would only deal with that if you have a specific issue such as the thin skull rule, because otherwise you're going to run out of time. You may look at defences, so someone may be partly to blame for the injury and they would have their damages reduced under the Contributory Negligence Act. Possibly the defence of consent or valenti might apply if the claimant knew of the risk and voluntarily accepted it. And lastly, you would mention that the remedy is damages. And here are some pictures to remind you of the relevant cases to see if you can name that case. And that's the end of the video. Thanks.